Well, good afternoon, everybody, and welcome to our McGuireWoods client webinar. Today, our topic is Federal Affirmative Action OFCCP Update, OFCCP's new scheduling letter, PDN rule, and other enforcement trends. My name is Brian Varger, and I'm a labor and employment and affirmative action partner in our firm's Charlotte, North Carolina office. Joining me is my fellow partner, Bill Doyle. Bill splits his time between our Raleigh and DC offices, and besides being a good friend and teammate on our affirmative action group, Bill was a former deputy director at OFCCP. But I'll be honest, we've gotten well past that, and we don't hold that against him anymore.
No, so, please don't.
Thanks to everybody for joining. We're going to have a good time today. Couple of things before we dive into our topic. Let me mention a few items about the platform itself. On your screen, you should see several icons. First, the resources icon should include a copy of the presentation. If you'd like, you can download that now or print it to follow along with the presentation. Second, you should also see a Q&A feature. You can use this to submit any questions you have throughout the webinar, which we'll try and address at the end. But to be honest, given our limited time together, we may not get to the questions submitted. We will, however, see all of them, and we'll work to circle back to you after our webinar is over. Also, Bill and my email addresses are on the slide at the very end of the deck. Please also note that this presentation is being recorded. We'll send a link to the recording together with another copy of the deck, excuse me, after the presentation is done. So feel free to share that with others, use it for yourself, or distribute as you like. So that's it for the instructions. As for our time together, we're going to actually cover three things in addition to questions. The general OFCCP enforcement trends that we've been seeing over the last governmental fiscal year, which ends on September the 30th, the new OFCCP supply and service audit scheduling letter, an itemized listing that was published at the very end of August, and the new OFCC pre-enforcement notice and conciliation procedures final rule, otherwise known as the PDN rule, which was issued on August the 9th. Just as a disclaimer, our discussion today is not meant to put you in a panic. It's simply meant to call out a few items to everyone as you plan and prepare, not just for audits, if they're on your horizon, but for the potential of audits and how to get into better compliance. But I'll be honest, I have to admit, as you'll see, there are a lot of changes afoot, and it's a lot to absorb. So we'll do our best to try and synthesize that for you. So let's start with leadership. First off, as you may have noticed, and as you can see on this slide, there's a lot of flux over at OFCCP. The current Secretary of Labor is actually an acting Secretary of Labor, Julie Sue, who was formerly Deputy Secretary of Labor for DOL. She's been acting since March after Marty Walsh resigned. And so far, she seems to appear to lack the votes for Senate confirmation. Related to all that, if you actually go down into the OFCCP structure itself, Michelle Hodge is acting director, Tina Williams is acting deputy director, Melissa Spear, who's an RD over in the SWARM, the Southwest and Rocky Mountain region of OFCCP. She recently retired and stepping in temporarily as acting regional director for SWARM, in addition to being regional director for Pacific region, is Jane Sir. So there's a lot of change within the department. Interesting question, does that open the door to potential constitutional challenges to any regulatory action? Bill and I had a discussion about this earlier. There is something called the Vacancies Act, which is a federal act that sort of puts limitations on how long someone can actually stand in the role and take official action as, quote, an acting secretary, as opposed to a real confirmed Senate appointed secretary. That Vacancy Act has a limit of 210 days, which would put Ms. Sue in the crosshairs beginning around October the 7th. Now, I've seen some chatter about whether that's really going to apply to her, since she was actually previously confirmed as the deputy secretary, and whether or not through some other pronunciations of Congress that she might have other authority to sort of issue regulations based on that. We'll have to see, but it's something to put in the back of your mind. I mean, the things we're talking about, the PDN rule, the new scheduling letter, this came out while Julie Sue is acting secretary. So we'll see if that gets challenges later on with respect to that, or maybe later enforcement. We'll see. As for audit activity over the last fiscal year, which again runs from October 1st to September 30th, we haven't quite finished up this current segment, but as you'll see, the number of closed audits is significantly down. This frankly continues the trend that has been going on for years across administrations. It's in part, frankly, a reflection about not just staffing levels at OFCCP, but how they approach audits themselves. And as we'll talk about later with the scheduling letter, goodness, the kinds of information they ask up front, the level of detail they get into has just expanded over the years. They have a tendency to dive deeply into every audit, as opposed to trying picking and choosing when they need to do more extensive reviews. And as a result, that's impacted their closed audit numbers. And so you'll see here for fiscal year 2023 under the Biden administration, it's down to 778 as last reported by the agency in July. Goodness, you know, even if that ticks up to, who knows, a whopping 800 or so, that's an 80% decrease from 2014. And so we'll see what comes of all this. You know, there's always been talk about the efficacy of OFCCP and whether or not it needs to be eliminated or frankly merged into EEOC, for example. And these numbers, frankly, aren't impressive. And my guess is, to the extent that people focus on this within Congress, again, it's likely to get some attention. Related to that, the trend with respect to financial conciliation agreed as opposed to a technical violation, boy, that's down as well. So far for fiscal year 2023, as of looking yesterday online in the FOIA reading room for OFCCP, the Biden administration this last fiscal year only had 19 financial conciliation agreements. It's, you know, not too surprising, but it's low even for a Democratic administration. And in fact, when you look at conciliation agreements over the years, even going back to goodness, Bush senior administration, you see this trend play out. It's the opposite of frankly what you might think. Typically, Democratic administrations tend to have longer audit periods. They tend to be a little bit more hyper aggressive with respect to notices of violation and their enforcement posture. They tend to be a little bit more aggressive with respect to they want with respect to settlement. And frankly, if they get too aggressive, people think, well, you know, that's worth fighting over. That's a lot of money. You know, I'd rather pay that to Bill and me than you, and we're not going to settle. And so what happens is it stretches out the audits, but it also decreases the conciliation agreement. So you'll see this not just during the Obama administration, but during the Biden administration. Their numbers are down compared to the Trump administration. That's partly a function of backlog, but it's also partly a function of approach. So we don't expect that to change a lot for the end of the year. But if you do have things that are in process, you know, all I would say is OFCCP is probably dealing. They probably would like to get these numbers up by the end of fiscal year 2023. And if you have an opportunity for a resolution, now may not be a terrible time to think about it. As for other sort of trends along the way, we just went through yet another AAP contractor portal certification here at the end of June. The numbers you see on this slide are the 2022 numbers plus the 2023 numbers as reported by OFCCP at the OFCCP sort of National Industry Liaison Conference that we had back in August. If you think about the numbers, reportedly back in 2022, OFCCP claimed that despite the certification numbers back in 2022, over 40% of contractors failed to certify on time. That's a huge number. Frankly, that's debatable, since it's partly based on what OFCCP thinks contractors should be in their portal and who should they think be certified, which many times can be wrong based on jurisdictional grounds. But still, if you think about that percentage, it's pretty off the mark. It went up some during 2023. You could see the number of parent companies went up, as did the number of establishments. But we haven't seen a percentage of compliance number yet from OFCCP. So we'll see what that turns out to be. Interestingly, as you may have heard last year, when OFCCP issued their corporate scheduling announcement list, that's their pre-audit list, back in January of this year, they indicated that everybody on that list, all of them, were individuals who had not certified by the deadline. They were trying to make a point of that. At NLIG, the acting director had indicated that when the new CSAL came out, would do 50-50 split, 50% individuals who hadn't certified, and frankly, 50% of others who had, but they simply want hairs again for audit, frankly, to try and get their financial numbers up and other things. I think that's a good thing. Interestingly, though, that's not what happened. As you may have seen in our legal alert that we sent out and otherwise, the OFCCP just announced their fall corporate scheduling announcement list here that was posted last Friday on September the 8th. And if you're not familiar with these things, it sounds like an official audit notice, but it's really not. Technically, the official audit notice is what Bill's going to be talking about, and I'm going to be talking about in a bit. That's the, quote, scheduling letter that you get at the kickoff of an official audit. This CSAL list is basically just a courtesy notice, that sort of a love letter. Dear Brian, I'm thinking about you, dreaming and hoping of our potential audit, love and kisses, DOL, right? And the idea behind it is so that folks can, in theory, prepare themselves for what's coming, because you typically only have 30 days to respond to the initial scheduling letter, which we'll discuss. And that's a lot of scramble. And so if you're on the CSAL list, it's good to check. And it's a good courtesy notice, but technically it's not the official start of the audit. On this current list, there are over 1,000 supply and service contractors that were listed, some of them multiple times, so it's actually done by establishment or location. And as far as the methodology, it's not, frankly, inclusive of individuals, it appears, that did not certify. When they discussed that methodology, OFCCP didn't say anything about that in their published list. Likewise, there's zero in the methodology description that talked about looking at EEO1 data, which has always been a common backbone for how you sort of target individuals for the CSAL list. Instead, if you actually look at their description, they said they're focusing on contractors who are, quote, engaged in low-wage industries. And they also looked at non-construction industries that received, quote, the highest frequency of contracts awarded through the bipartisan infrastructure bill. So there's probably a lot more behind that. But we know there are lots of folks on this webinar with us who are actually on the CSAL list. If you haven't checked it, you should go. It's a public list. You can look at this link here, or you can Google OFCCP 2023 CSAL. On that, you'll see several links. You'll want to click the link that says Fiscal Year 2023 CSAL Release 2. There was actually an earlier release, and so you don't want to click on that one. You want to definitely look at Release 2. And if you're on the list, again, that's not an indicator that you've done anything bad. I mean, this is not the same thing as a complaint notification. It's simply that because of these parameters for selection, your number has come up. So it's best to check, and certainly best to prepare. The other thing I'll say about the CSAL list, if you're thinking about industries, they've actually listed in the methodology the industries that they're, quote, picking on for this audit selection. You'll see here 7 of the industries out of 20 that's under the NAICS sector focus. Again, the thing to keep in mind about this, if you're in industry and you're on the CSAL list, and you think to yourself, I'm not sure I quite fit within that, just keep in mind that somehow partially related to what you yourself self-describe in your EEO1s and other data. So even though it may not quite fit you, it's part of function of how you sort of self-report. The other thing that I'll say is that just because you're not on a CSAL does not mean that you're not subject to potential audit. The CSAL notice is a courtesy notice, but they're not required to actually put you on that. And they can issue a scheduling letter to you without notice, even if you're not on the corporate scheduling announcement list. So with that, we're going to stop talking about enforcement and start talking about the scheduling letter itself.
Hi, everyone. It's Bill Doyle. Thanks for joining us. So OFCCP has radically changed its scheduling letter. This is perhaps one of the largest changes in the structure of the scheduling letter and the audit approach that OFCCP has ever embarked on. There's been changes over the years that have been a lot more incremental to different aspects of the scheduling letter. They proposed these radical changes last November. McGuireWoods and a host of other employer side commenters commented against it, both in January in response to the first round of OMB, OFCCP public interaction on the proposed changes. And then we also, many of the same entities also submitted comments on the employer side in May of this year. Unfortunately, the OFCCP did not really address most of the substantive employer comments. Those comments were universally against the changes in the scheduling letter. And the reason that the changes are so radical is that they take a process that was more of a tiered review structure where you started out with basic information and only required more detailed data or documents or materials for those particular areas where the initial submission showed some kind of a flag or a concern. That means that you were only providing information on a very discrete set of issues that you understood why the agency was making those requests generally, and it was focused on particular areas. They've inverted that structure and basically made it so that everybody in the initial response to the scheduling letter has to provide a lot more information up front, even without seeing areas that showed any kind of a concern. So they've inverted the approach to put a lot more burden on contractors. And this also has very significant implications for audit risk management with regard to the material risks of systemic discrimination claims by OFCCP, investigations that during the audit, which make the audit go on forever and become very costly to the employer, and or allegations of systemic discrimination, which typically focus on pay practices or hiring practices. Those are kind of the two areas that OFCCP has focused on in its audits and has found success in getting settlements or seeking enforcement litigation in those two particular areas. And so much of the audit is the outcome, the ideal outcome for OFCCP in an audit is find hiring or pay discrimination using statistical evaluation of the contractor's data that's submitted during the audit, and use that to allege a violation of Executive Order 11246, that there's either disparate treatment, disparate impact, discrimination seen in your hiring or pay practices. These are kind of affected class based type claims. They're not individual specific claims. They don't depend on any kind of complaint. It's very unusual that OFCCP ever has or is able to identify anecdotal evidence of discrimination. These are typically statistically based cases. And so the new things that we're seeing in the request in the scheduling letter are items that will have risk implications because they relate to how OFCCP is going to be able to justify the structures of the statistical analyses that it uses when it evaluates your data, with, again, the end outcome that the agency wants. Their ideal outcome is spend a bunch of time in your data, in your workplace, in your policies, and at the end of the road, be able to identify statistically significant disparities and use that as a basis to allege systemic discrimination and obtain a settlement, a financial settlement that then they would report on to Congress and to the numbers that Brian was showing earlier. So we'll get into some of these. Here's where you can find just links to the scheduling letter. And OFCCP issued some FAQs related to the scheduling letter, where you'll see a lot of the FAQs relate to the compensation data request that we'll talk about. So we'll talk about 4 major changes here to the scheduling letter that really have significant risk management implications for the way you approach the audit and think about managing the risk of a negative audit outcome very early here in the going into an audit, when you have an opportunity to look at your data and try to forecast things before you make submissions to OFCCP. So the first big change out of the scheduling letter is, well, what is the scope of the audit? So OFCCP is now saying, and this is not a part of the itemized listing, but is actually text in the scheduling letter itself. They're saying if you have a campus-like setting, and that's in a particular establishment that is in the city that that they're seeking to audit, then you're supposed to provide APs for all the establishments in that city. So obviously, if you're submitting 4 or 5 or 6 different affirmative action programs because you have that many establishments in the city, that's going to affect the scope of the audit. Instead of being 1 establishment, it would be 5. That means bigger workforce head counts. When they process it using statistical analysis techniques, there are going to be larger sample sizes, even small statistical disparities could be statistically significant. So that's part of why OFCCP is trying to seek to do this, is to have a bigger sample size for seeking to evaluate the data. This is one you really need to talk to counsel about, because there's a bunch of aspects to this where you would find, you're not going to find something where there's a very crisp definition of campus-like setting and how this would apply. And so before you think about what am I going to submit to OFCCP in this scenario, you definitely need to have a particularized discussion with counsel around this, because there's enough kind of open texture on these issues that you really need to have a specific discussion to understand what you're going to do and what the risk profile looks like. Number 2, and this is the compensation data, where the OFCCP has really expanded significantly the requests, and this is found in the item 19 request. So the first thing that they're changing is they're wanting 2 years of data instead of 1. So this is individual specific data on the entire AAP workforce. It used to be that they would get 1 year of 1 year snapshot of that data. Now they're going to get 2 years of that data, and that has significant risk implications we'll talk about. They are also requiring in item 19B for you to disclose any factors that are important or used in making pay decisions or influential in explaining pay decisions, and that they want any data related to those factors that you have available. And so they're not just getting kind of enough information to do somewhat of a mini regression. They're now asking for complete data to do a full regression study across the entire AAP workforce in comparison to what they used to do, which is make a follow-up request for data. Now, often that follow-up request was as broad as the entire workforce, but nonetheless, this will marginally increase the amount of data they have to conduct large-scale regression analyses across all your workforce data. Then in item 19C, they're requesting policies and guidelines and training materials related to the functioning of your compensation system, your structures, these types of things that, again, and you can see in the bottom of the slide there is the text from the actual request of the types of compensation policy documents and materials. And again, they would typically get this type of information much later in the audit where they're focused on something. Now they're getting this information, these materials right up front. And so the risk management implications of this are probably the most profound out of any of the changes in the scheduling letter. The 2 years of data will allow the agency to do temporally aggregated regression, which basically means they're going to be able to double the sample size. So if you think you have a workforce of 500 employees that in a particular regression study that they could run, given that they have 2 years of data, that means they have 1,000 observations now to include in a regression model. Now, we don't have time to go into kind of the technical details and defenses and things like this. We are going to provide everybody updated legal alert. We did a first legal alert when the scheduling letter came out that provided an overview of the scheduling letter changes. We're going to have a supplemental legal alert that goes into detail, focused on the risk management implications and talking in more detail about some of the technical aspects of these items. We just don't have time to focus on each one in the detail that it really deserves. The requirement that you include both policies and the factors would have risk management implications, because if there's factors, for example, that you don't provide initially, you could expect later on in the audit when OFCCP is making an allegation, and then you say, oh, wait a minute, this factor actually was important for that particular group that you're focused on, then OFCCP is going to raise estoppel arguments, they're going to raise credibility arguments as to, well, why didn't you provide that right up front? So that's very challenging to really understand what factors might be relevant, at some later stage in the audit and relevant in relation to the types of statistical models that OFCCP might run. And then the policy documents would either support OFCCP's view on what factors are or not important to include in the model. Obviously, if your policy documents never discuss a factor, then OFCCP is going to argue, well, that must mean we don't need a control for that factor. And really importantly, if your policy documents discuss the decision-making process around making pay decisions, then that is highly relevant to how you should aggregate the statistics, because the Supreme Court said in Dukes versus Walmart that the statistical aggregation in a pay analysis is relevant and reliable only when it's aggregated around a common pay decision maker or around a common pay practice that's allegedly challenged as causing a disparate impact. So your policy documents are going to really, from a risk perspective, the key aspect of it is how does any of this relate to the structure of the statistical analytics that OFCCP would run and that we would want to run in defending the audit. This big change number 3 is really something that I think is going to require, this is item number 22, and this is something from a risk perspective that the 2 risk aspects of this are, number 1, it is going to serve as a massive distraction for employers where they're going to spend a lot of time churning on this and not focus on the real significant risk of systemic hiring or systemic compensation discrimination allegations. And number 2, employers risk making submissions to OFCCP in response to this item number 22 that shoot themselves in the foot. And it shoot themselves in the foot by giving justification for OFCCP in the way OFCCP structures its analytics of your pay data and uses arguments based on your item 22 submission. So item 22 is there's an AAP self-analysis, compensation self-analysis requirement. It's completely unspecified what that needs to look like. And it's an AAP requirement. It doesn't relate to allegation of systemic discrimination or at all. It's you have to comply with this AAP requirement. If you don't comply, the negative aspects of this and the risk related to this are much lower than the risk related to allegations of systemic discrimination. See, that's why you really need to not let this distract you. You really need to talk to counsel because this is very nuanced, especially with regard to privilege waivers and privilege objections and the scope of the objection becoming an issue in third-party litigation or enforcement litigation with OFCCP. And you'll see a long discussion of this topic in our legal alert, but it really demands a very focused discussion with experienced counsel on this issue, but it's not the prize. You know, keep the eye on the prize, which is the other items that really would entail significant risk. This is just the text of that's the text of the request there. And obviously, the OFCCP is claiming if you gave this information, it wouldn't be a privilege waiver of something that you might consider to be otherwise privileged. And you know, you can doubt that especially given, for example, the last bullet here, what they want you to explain and some of the other aspects of the request. So this big change number 4 goes to hiring discrimination, and systemic hiring discrimination has been OFCCP's bread and butter. It's probably 60 to 80% of their settlements historically have been systemic hiring discrimination claims. They feel comfortable with those types of analyses. They feel comfortable litigating those types of cases. They've had success in litigating those types of cases, both under a disparate treatment pattern or practice theory and under a disparate impact theory. So this is an area where you really have to focus along with the systemic comp issue. And OFCCP has changed the scheduling letter to require, they've always required submission of the raw data, but now you're going to have to submit the policy materials related to your hiring practices. And again, OFCCP is going to use those materials in relationship to how they justify the structuring of their statistical and analytics around technical statistical issues about aggregation, who they include in the regression or other statistical model, what control factors they're using, and what control factors or groupings they're using to compare similarly situated candidates. Your policy documents have to be considered from that vantage point, which requires a risk assessment that combines the statistical outlook with a review of those policy documents and how they relate to the implications for what justifications OFCCP might have in the way of structuring their statistical analyses. OFCCP is also focused on artificial intelligence, and this is a big hot issue that all the regulators are focused on now, because they're really behind the curve on artificial intelligence. It's really gotten way out ahead of them. And so that's something that they're asking for you to disclose. And again, you should consult with experienced counsel on these issues. We've been helping clients with these types of issues in various different state and laws, and looking at from a federal regulatory perspective. And there's lots of complex issues with regard to that again, you'll see in our legal alert. OFCCP has no policy guidance at all on artificial intelligence that's meaningful in any way. And this is something that you'll want to look at, but it's more kind of the hot issue. And again, it would be something that you would want to review with counsel, but it really is going to be something that is going to be encompassed somewhat within the statistical risk management that you'll want to do going into the audit. So let me turn it over to Brian, and we'll, like I said, the legal alert will cover a lot of these topics in more detail. It really is a broad area that requires a lot more kind of discussion than we had time to give it.
Yeah, thank you, Bill. So yeah, I'm just going to cover a couple of other scheduling letter changes, and then we'll jump into the PDN rule, which is important. Just to be clear for folks who aren't as familiar with the scheduling letter, the things that we're talking about today are not the entire scheduling letter. The scheduling letter has all sorts of pieces and parts to it that aren't changing, that are remain. It goes on and on and on for multiple pages, for 20 plus different requests for information. It's quite burdensome. So when we're talking about these changes, we're talking about the big substantive changes to what was previously sort of being utilized by the OFCCP. This is not meant to be, just to be clear, a summary of everything in the scheduling letter. But you get the sense of what we're talking about, though. It's burdensome. And as Bill said, you know, keep your eye on the prize. There are some things in a scheduling letter response that are much more important than others. And so some of these changes, likewise, are more important than others. This change right here, big change number 5, more action and recruitment and outreach information up front. It's a big change, but again, on the risk side of things, not much risk, because if you violate it, if you don't give up information that they think is sufficient, if it doesn't comply with their expectations, what's the harm? Not much, really. It's a technical violation, maybe, but it's certainly not a financial violation. And so the only change here really is they normally ask for this information as part of a request for information as a follow-up to the initial submissions. It normally came a month or 2 or 3 down into the audit. Now, all of this is being moved up front, and they're also adding this new requirement at the end that in the event with respect to, for example, veterans and disabled individuals, that the analytics with respect to outreach were determined to be ineffective by you. They want to know what you did about that. Not a terrible question. It normally comes up in the audit, not a huge risk, but now they're moving that up front. Other things that's going up front, well, documentation that includes established policies to describe your practices related to promotions. This is exactly sort of an echo of the same issue that Bill said about wanting to see comp policies and hiring and selection policies and recruitment policies up front. Frankly, those are much more risky to you than promotion policies. It's not that it's not important. It's not that OFCCP doesn't audit on promotions, but let's be honest, as Bill said, that is not their bread and butter, because promotion claims are very hard to prove. They would much rather delve into compensation or definitely hiring and firing. But just so you know, promotion policies are on deck as well. Likewise, they typically always ask for this as part of a request for information, but they're now asking for information about your EEO policies, anti-harassment policies, et cetera, up front, which would include your arbitration agreements to the extent that you use them. Other things that's changed, they've always asked over the last several years for reasonable accommodation information that's focused on the last preceding AAP year. They've now expanded that out to include the first 6 months of the current AAP if you're 6 months or more into that plan. as of the time of the scheduling letter. They're also asking for information about individuals. If somebody's underutilized, individual with disability, they want to know what steps you've taken to determine whether there are impediments that cause that. Now, of course, the biggest impediment, frankly, is the self-identification form that OFCCP makes us use, because most people look at that and say, I don't want to disclose that. And so your numbers are off, and typically will always be off unless you do a good job of encouraging individuals to self-identify. But they now want you to identify not only sort of what your numbers are, but what steps you've taken to try and analyze whether there are any barriers. And likewise, at the end of this, you'll see that they're now, if you happen to be a post-secondary school, some of the information that you normally had to submit, again, later on in the review, they're now asking for up front with respect to the IPEDS report. So that's it for the scheduling letter changes themselves. One thing I will note that I do think is a big change is the way that they're going to send it out. And I think this is important. They normally would send it by certified mail in a hard copy postal service document that hits someone's real live desk. No more. They say they're going to now change that to do transmission by email. And I don't know about you, but I have no idea where that's going to go. In theory, it should go to the individual who's probably your designated contact for EEO1 reporting, and they'll probably utilize that. But that changes from time to time, and frankly, people get thousands of emails a week, and hitting the door in this manner to start the clock for responding, boy, I think that's a huge change. So internally, you should let your folks know to be on the lookout for these things and not simply to sit on them. As far as your response submissions, they thought about requiring electronic submission response via a platform. They did not do that, but they, quote, encouraged people to do that. The other thing to know, with respect to extensions, under the last sort of administration, Director Lean, I think, and others sort of softened up the timelines, not so much required 30-day response, but their willingness to be a little flexible with respect to that in light of the burden of the submissions. No more. They've been very clear that extensions to the scheduling letter response, when you normally only have 30 days to respond, are going to be given, quote, in extraordinary circumstances only. The examples that you see here are the examples from their own information on this. Basically, you got to be dying or you got to be thinking about dying. But otherwise, good luck. Now, having said all this, Bill and I would tell you, by way of advice, keep in mind when you think about these scheduling letter submissions, if you look at the long scheduling letter, there's some things that OFCCP expects to have on the shelf, right? An AAP, for example, that they're not going to be very sympathetic about a 30-day extension. Likewise, there are a lot of things in the scheduling letter that require compilation, and you don't necessarily have it ready at hand, like a lot of the comp data. And if you need more time to compile that type of information, we would typically say ask for it. Regardless of whether they're going to grant it or not, regardless of whether they're going to give you a hard time about it, you're much better submitting information that is as clean and robust and is fact-specific and, frankly, puts you in the best light as possible out of the box in a scheduling letter response than to rush to hit the 30-day deadline, submit information that's incorrect, and then spend a lot of time explaining it. So this is technically the rule, but I would take it with a little bit of a grain of salt. So shifting gears now to the PDN rule, and then we'll hopefully get some time for questions. For folks who aren't familiar with this, the PDN rule stands for the new Pre-Enforcement Notice and Conciliation Procedures Final Rule. There was something like this earlier under Director Lean. This actually modifies and revokes the prior, quote, non-discrimination obligations of federal contractors and subcontractors procedures to resolve pre-employment discrimination that was issued back in 2022. That was a nod by Director Lean to be more clear, to be more transparent, to be more upfront about the standards, and frankly, just try and pull back on some of the excesses of OFCCP with respect to how they issued notices of violation and dealt with conciliation. It was published effective on October 4th and went into effect on September the 4th. OFCCP interestingly says that it's going to be applied to, quote, current audits without a PDN as of the date of publication. Between you and me, you ought to talk to counsel about that. If you've got an ongoing audit and hasn't had a PDN yet, but it started under the prior rule, I might argue, frankly, that the prior rule applies to you no matter what they say about that. But that's something you ought to discuss with counsel. Interestingly enough, at ILG, Michelle Hodge said, this new rule is going to be coming out, quote, in the coming days. It then hit everyone's desk literally 24 hours after she said that. So apparently their definition of days and my definition of days aren't the same. But if you want to actually look at the rule itself, we've got links to the rule and to the crosswalk and to OFCCP's FAQs about that. The spin from OFCCP about this, and this is not my spin, this is their spin, coming out of ILG, Director of Policy, Tina Williams, indicated that, this new rule retains the early resolution option, the ERCAs, that are very popular, frankly, with OFCCP and contractors. No surprise there. PDNs, predetermination notices, and notices of violations are, quote, still codified and in use. No surprise there. But then the rest of the spin between you and me, boy, it's a lot of fluff. They claim to remove aspects that made them duplicative. Well, they really aren't duplicative for reasons we'll talk about. They definitely rescinded the definitions of qualitative and quantitative evidence. That's significant from a proof standpoint. Boy, this spin I highly object to. They rescinded, quote, evidentiary standards and, quote, went back to applying Title VII standards, which we'll talk about in just a second. I think is really the opposite. There's been a lot of debate with contractors and OFCCP about the standards they apply and the fact that they really don't follow good Title VII case law with respect to proof structures under their PDNs and NOVs. The idea that they went, quote, went back. Well, they absolutely went back, but they went back, frankly, to their freewheeling definition of what they think is Title VII standards, in my opinion. And then, interestingly, they said they thought to create a streamlined, efficient, and flexible process, and our goal is to be, quote, as transparent as we can. That was probably the most honest thing they said between you and me. I think that's probably the most honest, because when they mean flexible, they mean they will share information with you when they want, how they want. And when they talk about being transparent as we can, that frankly is a return to hiding the ball. And so I guess Bill and I will close out with a discussion about this, but when you actually look deeply at it and compare it to the prior rule, it eliminates the regulatory standards that Director Lean tried to specify more clearly in the last rule on this. And it went back to the idea that they don't necessarily have to disclose minimum bases for the reasons that they're moving forward with a notice of violation. They'll typically tell you what their statistical sort of numbers are in their final conclusions. But if you actually want to delve into the detailed factual basis for that, now, as in the past, they're going to say, we don't have to do that. So, for example, the big question that a lot of people will say is, okay, you spent a year and a half auditing us. You've looked at all our data. You spent a week on site with us. Tell me, is this a pattern and practice disparate treatment case where you think there's direct discrimination? Do you think it's purely a statistical disparate impact case? Or is it both? And now, under the new PDN rule, they'll say, we don't have to tell you that. We'll, quote, save that for enforcement. Of course, I always thought PDNs and NOVs were enforcement, but they've gone back to their original sort of no comment pattern, which I think is very, very negative. The other thing, again, this goes back to the Title VII rules. They don't have to identify under the new PDN and NOV rule the particular employment practice that caused alleged disparate impact discrimination, because it's not enough, frankly, under Title VII law to simply say, we looked at the numbers, we think that there is disparate impact when it comes to hiring selection between A and B, and here's our numbers and here's our modeling. they have to then say, and by the way, we think it's caused by X. We think it's caused by the manner in which you conduct interviews. We think it's caused by hiring manager X. We think it's caused by the fact that you're using sort of minimal qualifications that screen out individuals with a criminal history, or whatever the reason is. They need to actually articulate a cause, because in turn, you have a defense to come back and say, well, we have good non-discriminatory reasons for that basis, and they are necessary for our business operations, and there's not a good alternative to using what we're using. That is actually a legitimate defense, but you can't make that defense if you don't know what the practice they're talking about of concern. Now, under the new PDN rule, they're back to that sort of crazy position. But Bill, other thoughts about that before we move to the next slide?
Yeah, when you think about this, it's going to make it more frustrating to interact with OFCCP. We did a long legal alert about this. I think we can recirculate that. It was a month or so ago when the PDN rule was finalized that discussed a lot of these issues. I mean, there's some defenses that or angles that employers can take to try to pry things out of OFCCP, but it definitely will create some frustration. And when you think about it, nobody's going to pay $5 or $10 million for a systemic discrimination settlement where OFCCP is hiding the ball. So this is not going to work for them for larger cases. Where it might make a difference is you're going to see a lot more allegations that are weak and marginal, and especially in cases where the valuation or the value implication of those marginal weak allegations is lower than the cost of litigating the matter, or pretty, almost, I wouldn't want to say nuisance value, but not a large cost amount, and where the cost of continuing to defend the investigation and certainly the cost of litigating might far exceed what OFCCP is demanding in a settlement. So if they can get a $250,000 settlement and they can get 40 or 50 of those types of settlements, that might equal like one $5 million settlement. So this is kind of like a play to go after smaller cases with weaker allegations. And that's where I think you're going to see this type of thing play out the most. In any kind of case, it's probably going to happen. And even in the bigger ones, you're going to have some degree of frustration. But I think ultimately you'll be able to pry, if you're using experienced counsel, you'll be able to pry the necessary information out of OFCCP, or at least have strong enough defenses over what you can infer are their allegations.
Yeah, I agree with that. I think the other important thing you'll see on this slide, a couple other sort of changes to with the PDN rule, but one big thing that's out there is they're now taking the position that, despite the prior rule with Director Lean, they can add into new allegations into an NOV that aren't included in the predetermination notice. And so it's sort of a gotcha approach where they can sit down and have a conversation with you and say, oh, by the way, we think you're doing X, Y, and Z. And you can say, well, we disagree, in part because we have no idea what you're talking about. And they will go, well, you really ought to settle for us for X amount. And you would say, well, I don't know about that. And they would say, well, and by the way, our evaluation is, quote, ongoing. And, when it comes out to the final NOV, we may come up with some other things that we have concerns about. So the number may go up. So you really ought to settle with us now. That's hardly a way to run the railroad, but that's what the new PDN rule allows them to do. So the other thing that they're trying to do is in the body of the PDN rule, and this is a little wonky, but they try and lower the standard for what they deem to be, quote, adequate conciliation efforts in order to move on to enforcement. Query whether they can really do that, since there are other sort of regulatory limits on what is deemed to be adequate conciliation. but they're trying to make a run at that with the language that they put in the PDN rule itself. So just a couple of notes. I know we're about out of time, and I want to make a couple comments about things to think about and maybe try to address a couple questions. You can see these homework suggestions here, but I think the theme of these suggestions is try to get ahead of this, both with respect to your policies and practices and how you describe them. As Bill mentioned, you know, what you have in the documentation is going to be used against you to try and claim that anything you omit is somehow not a consideration. And then they're going to flip that back around on you and claim that you're not entitled to use that as a controlling element with respect to regression and other analyses. It's a hyper-aggressive kind of position to take with respect to these policies. But, you know, you ought to think about sort of tweaking things around the edges and how you describe them up front so that you're not scrambling last minute when you do get one of these scheduling notices. Likewise, you know, there's going to be a heavier premium on tracking information, especially with respect to outreach and documentation and recruiting. That's been the case for years. They're only increasing that. You know, getting your team up front and ready on that as the year goes on is certainly a lot easier than trying to scramble on the back end to sort of recreate history. So let me raise a couple questions here with our limited time at the end, Bill, and then we'll wrap up. There's one interesting question that I saw someone raise, and I'd seen this too, and it's a good point of clarification. They indicated, can you please confirm, I read an article that the time to respond to a predetermination notice was reduced from 30 days to 15 days. Is that correct? And the answer to that is yes, that is correct. Now, that's not the scheduling letter response. The scheduling letter response is still 30 days absent an extension. But they have reduced the time period to respond to PDN to 15 days. Now, again, you can ask for a response, but that's what they're claiming. And boy, you know, if you think about it, that's quite a change. I mean, OSP sometimes audits individuals for 6 months, 12 months, 2 years, have all this time to look at the data, look at your information, think about their theory, put together a PDN, and then they're going to give you 15 days to come up with your substantive response. A little aggressive, but that technically, the person who asked, Debbie, is right. It has been reduced. Bill, there's another question, and then we'll close on this. It had to do with your campus question and discussion, Bill. It says, does the locations in the same city truly need to have some location connection to them? Or if you have 7 locations, for example, in New York City, but spread miles apart, would they still combine locations as part of one, quote, campus? Have any thoughts about that?
Yeah, I mean, that's the kind of thing that I think you have to have a specific discussion with counsel, you know, privileged discussion for thoughts on that and how to address that, right? I mean, OFCCP doesn't necessarily have line of sight to the specific factors that go into whether something is or is not a campus-like setting. And so you have to think through that with counsel in terms of whether, you know, what your submission scope would look like and what the risk implications are for the various options. Obviously, from a risk management perspective, you'd like to keep the profile as limited as possible. And I think that's the question mark in that discussion is, well, what is our obligation vis-a-vis these question marks about, you know, an unclear definition of a campus-like setting and the factors that go into that determination. So that's where I think you would want to have those discussions and sort out what you think the appropriate response to the agency should be in terms of what you're making in the submission. You don't give a submission that says, here's our thought on that. You give them an AAP or a set of AAPs, and that's the question mark. You know, what AAPs are you going to give them? That's what you need to sort out. I would also say, just in terms of wrap up, those folks on the CSAL list really want to use that time constructively right now between now and when they get the scheduling letter to really do a privileged risk analysis that looks at the statistics, because the statistics drive everything here. So you have to look at the statistics, and then you have to bring in these questions about the policy documents, the factors, all these other things as in the submission that we've talked about that are going to relate to how the arguments will go between OFCCP and the defense on how the analysis, the statistical analysis should be structured. So that's something that you really need to get out in front of right now and use that time to focus on that. I would not be, trying to just scurry around looking for things that are not really going to be as critically important in the overall submission in terms of how it relates to your risk profile. They kind of have overwhelmed you here. It's like a discovery response where they submitted a truckload of information, and hiding in there are like 5 or 6 really important key documents. That's kind of what you got in this situation. And you really have to stay focused to not become overwhelmed and not lose the attention on the risk management aspects.
Well, I think we're out of time, everyone, and we appreciate your patience. We appreciate you joining. We know, goodness, you have a lot of things on your plate, and we're sorry to be adding to them with discussions about new regulations, but we are getting towards the end of the fiscal year, and DOL and other agencies are definitely pushing out a lot of things. There may be other things coming out of DOL separately from OFCCP with respect to wage and hour and other pronunciations. I noticed the National Labor Relations Board Council just issued an interesting notice today with respect to non-compete. So there's a lot of flurry, but Bill and I and others on our team certainly are happy to help you digest all that and try and prioritize issues. If you have questions, certainly for us afterwards, here's our email addresses. You can find us on our website. Most of you know us. We're certainly happy to lend a hand anytime. And like we said before, please feel free to share this deck with others. The more, the merrier. But thank you. And Bill, thanks. And we'll talk to everyone soon.
Yeah, thank you, everyone. Thanks, Brian.